Welcome back, everyone. We are almost at the tail of contract law. So today we will discuss about assignment and third-party rights in our chapter 12. So this chapter is about who gets the benefit of a promise and who can enforce it when things go wrong in contract. Normally, only those who made the deal can rely on it, like who made the contract agreement, they can rely on it. This is the principle of privity of contract. But as we shall see, the law eventually realized that business life would grind to a halt if no one could transfer rights and enforce contracts made for their benefit. So the law allows two key exceptions. Number one is assignment, where rights are transferred to another person, and number two, third-party rights, where someone outside the contract is given the power to enforce it, like at that point. So let's start with the old-fashioned rule under privity of contract first, and then we will build upon it. So the doctrine of privity of contract says that only parties to a contract can enforce or be bound by it. This was famously illustrated in the case of Twiddle versus Atkinson, 1861. Two different fathers, agreed to pay money to a couple upon their marriage. The son of the intended recipient tried to sue when payment never arrived. The court said no. He was not a party to the agreement. He may have been the intended beneficiary, but he was legally invisible here. So the rule was confirmed again in Dunlop versus Selfridge, where a manufacturer tried to sue a retailer for selling like below a set price, like a set price was agreed, but they sold it under that price. Even though their contract was with a wholesaler, Lord Haldane basically said, nice try, but you are a stranger to contract, so you can't enforce it. So under strict privity, outsiders get no rights and only contracting parties can sue. Good news for legal pursuits, bad news for pretty much everyone else at that point. So it was kind of strict rule, and that's the general rule as well. So now let's talk about exception to privity. Before Parliament stepped in, judges tried to soften privity, they became flexible. With creative exceptions, a sort of like judicial DIY they have done. So number one, trust of contractual right. One party could hold rights on trust for others. That was under common law. Another thing that emerged, collateral contract, separate side agreements. So where there was another case, we got like Shanklin Pierce case where a paint manufacturer was liable on a promise made to someone who was not technically their customer at that point. Once again, collateral contract came in to create an exception or soften the concept of privity of contract. Number three, agency. The agent contracts on behalf of principal, allowing enforcement by the real party in interest. So this was another thing created by common law. So assignment, transferring benefits only to another person. That also came into discussion. So restrictive covenant on land, like Tolk versus Mogsay, that was another case law where a buyer had to honor a promise made by a previous owner not to build on the land at that point. So that restrictive covenant transferred to next person in land law. So these exceptions helped, but they were patchy, unpredictable, and confusing. So Parliament eventually tidied everything, and they introduced Contract Rights of Third Parties Act in 1999. So this is a new regime. So we talked about general privity of contract, strict interpretation, and common law flexibility, and let's talk about statutes. So this act was a modern, sensible reform, the legal equivalent of finally updating Windows 95, because that's not working. So under Section 1, a third party can enforce a contract if the contract expressly provides that they may. Or number 2, the term purports to confer a benefit on them unless the parties intend otherwise. So third party must be identified by name, class or description, but need not even exist when the contract is made. For example, a contract can benefit future employees or subcontractors. So the Act made life much easier for commercial contracts. For example, insurance, beneficiaries, subcontractors, and even family members named in contract can become beneficiaries of contracts under statutes and under law. So the next thing is rights and limits under the Act, 1999 Act. Once the third party qualifies, they can enforce the relevant term as if they were contracting parties. They can claim damages or seek specific performance, but their rights are not limitless. The parties can exclude third party rights if they wish. This Act does not apply on certain contract that you have done, like for example a job contract, and they say this contract does not apply on this contract that we are making, or we are excluding the contract from the Act from our contract. So under Section 3, the third party's rights are subject to same defenses the promisor could use against the original promisee. And under Section 2, once the third party's right have crystallized, the original party cannot vary or cancel the contract without the third party's consent, and that makes sense. So we got another case. Cleve's case confirmed that a shipbroker could enforce a commission clause under the Act, a rare example of English law being both fair and commercially efficient, of course. It is efficient, but that's on lighter note. So assignment. Let's learn about it. Assignment is the process by which one party, the assigner, transfers their right under a contract to another, the assignee. Only benefits can be assigned, not burdens. That's what we need to keep in mind. In other words, you can pass on your right to receive payment, but not your duty to deliver the goods at that point. That I will receive payment and they will deliver the goods at that point. So once assigned, the assignee can sue the debtor directly without the assigner's involvement, provided proper notice is given. So assignments are crucial in banking, insurance, and business sales, all of them. For instance, when a company sells its debt book, it is really assigning hundreds of individual contract rights in one go to other parties. So the next thing is legal and equitable assignment. There are two main types of assignment, legal and equitable. Legal assignment is governed by Section 136 of the Law of Property Act 1925. To be valid, it must be in writing and signed by the assigner. Number 2, be absolute, not partial or conditional. And 3, the debtor must be given notice. Once complete, the assignee can sue the debtor directly. Equitable assignment, on the other hand, is less formal. It may be oral or incomplete in writing. However, the debtor can still pay the assigner until notice is received. So another case, in Williams' case, 1905, the court upheld an equitable assignment because the parties clearly intended a transfer, even though not all formalities were met. So remember, legal assignment gives full rights and clarity, while equitable assignment is flexible, but at the same time, it is riskier. So, limits on assignment. Assignment has its limits. You cannot assign obligation or burdens. Contracts of a personal nature, such as artistic or professional services. For example, I tell you I will come and teach you personally at that point. So I can't say that one of my students will come and teach you at that point. Contract of a personal nature, or a musician, For example, you just hire Dua Lipa and she says, I'm sick, someone else will come and perform it. No, it will not work. Contracts that contain a prohibition on assignment. For example, assignment in Portland Cement case 1903, assignment was allowed because the contract was commercial and not personal in nature. But if the contract is based on skills, reputation, or trust, assignment is barred. You cannot delegate your genius, your intellect at that point. Also, the debtor must be properly notified. Otherwise, they can lawfully pay the assigner again, leaving the assignee chasing shadow. In commercial law, anti-assignment clauses are common to maintain control over the parties at that point. Our favorite slide, SQE1, tips and pitfalls. So in tips, always start with privity. Only parties can enforce or be bound. Number 2, then show how either assignment or the 1999 Act creates exceptions. For assignment, cite 136, that's the law, and distinguish between legal and equitable assignment. For third-party rights, there is Contract Rights of Third Parties Act 1999, and that's section 1 to 3. Emphasize that only benefits, not burdens, can be assigned. Identify roles clearly. Who is assigner, who is assignee, and who is debtor. So, pitfall, confusing assignment with novation. Novation is a new contract, formation of a new contract with new party. Forgetting the notice requirement for legal assignment. You need to give notice to debtor that there is assignment going on. Assuming all third-party beneficiaries can sue only if the contract allows or benefits them directly. In that case, they can, otherwise they cannot. Ignoring that the 1999 Act can be excluded by express clauses, it can be excluded. Forgetting that personal contract cannot be assigned. So all of it, keep in mind once you are sitting in your SQE. I wish you all the best. If you like this session, subscribe our channel and share it with your friends. Ta-ra!